of law, but really called into question his ability to continue to sit as a judge in a way that was impartial and in keeping with notions of judicial integrity, given the way that he had treated the complainant in this case.
Okay, that's interesting. Could you give me can you give me examples? Can you give me for example, what was going on in this trial that made it so bad?
Yeah, so there were a number of times during the course of the trial that the trial judge referred to the complainant as the accused, on numerous occasions, and the Crown tried to correct his nomenclature several times, and he just kept falling back into it, which I think is reflective in some ways of the fact that she was in many ways on trial in this particular case. Judge Camp asked the complainant questions such as, why didn't you just keep your knees together? Why didn't you sink your bottom down into the sink so that the accused couldn't penetrate her? Questions that really seemed to reflect an obligation on her to fight off the sexual assault assailant, and I think bring into question the appropriate interpretation of the consent provisions of the criminal code. So because we have a yes means yes standard of consent, that means that when the complainant makes it clear to the accused that she does not want to participate in the sexual activity in question, that should be the end of it. She's not consenting. Justice Camp seemed to be imposing a sort of extraordinary standard on her to fight off her assailant, which really goes beyond the law of consent as we know it. So he seemed to be disregarding the consent provisions of the criminal code, and similarly he disregarded and in fact called into question explicitly the rape shield provisions of the criminal code. He said they didn't make sense, they were counterintuitive, they didn't reflect common sense in terms of what we know about complainants' other sexual activity having a bearing on whether they consented on the occasion in question, whether they had the wherewithal to fight off a 240-pound man when they were only 100 pounds. So he actually seemed to be not just disregarding the rape shield provisions of the criminal code, but essentially saying he didn't agree with them and he wasn't going to follow them in this particular case. And so there were a couple of instances in the case where he actually took into account the complainant's other sexual activity without going through the procedural protections that the rape shield provisions provide in the criminal code. And so it was through that series of examples that we came to believe that not only had he made errors of law that could be adequately corrected by the Court of Appeal calling a new trial, but that he had actually brought the administration of justice into disrepute. I think had made it very difficult for women or men reading that judgment to come forward with complaints of sexual assault, knowing that they would literally be on trial in these kinds of cases, and that's why we decided to make the complaint.
Okay, all right. Well, I think that makes sense to me. Now, you're. I think we've covered everything that I wanted to go through. Okay, you've been pretty clear on that. Was there anything else that you wanted to cover? Anything else that you think that you'd like to get out there?
Yeah, a couple of things, I guess.
Sure.
I want to say that we didn't make the decision to make this complaint lightly.
Right.
Because all of us believe very strongly in the principle of judicial independence. And the whole idea of judicial independence, I think, is such that you don't want to lightly interfere with a judge's role and functions as a member of the court.
Right. Judges make mistakes, right? That's why we have appeal courts.
Exactly.
Right? I mean, they're only human, and some will misapply the law, inadvertently misapply the law, right? And this is why we have appeal courts. Only the Supreme Court doesn't make mistakes, right?
Right. Yeah. That's right.
Right. Yeah.
So, and we used to have the Privy Council, and
that's right. Yeah, that's right. Well, we've got rid of that, but there you go.
Yeah.
Well, at least keep it in Canada, eh?
That's right. So anyway, yeah, we did not take this decision lightly, but I think by the time all four of us had read the trial transcript in the case, we really felt that this was a matter that needed to come to public attention. The other thing that I would mention is that we have a faculty blog that some of your viewers will probably already know about.
I'll link to it. How about that?
Okay,
Yeah, excellent.
Yeah,
you send me a link and
I'll
we'll
send you a link.
Yeah, awesome.
And you can post it on your YouTube site. But both Alice Woolley and I wrote blogs about our different perceptions of the of the case, which is called the Wager case for people who want to find it. So maybe we can add a link to the
Sure.
Court of Appeal decision as well.
Yep.
My blog post deals with some of the myths and stereotypes that were evident in Justice Camp's reasons, and Alice Woolley, who's more of a scholar on lawyer and judicial ethics, writes more from the perspective of judicial ethics. And I think it was through that process of reading the transcripts, writing about the case from our own individual perspectives, and talking to our colleagues elsewhere, that we decided that we really, somebody had to bring this matter forward for the Judicial Council's consideration. And I guess the one other thing I would add is that we got a lot of feedback from members of the profession and from members of the public after we filed the complaint.
National news.
It made the
It
national
really
news,
was.
and even
Yeah.
internationally. I was on
Yeah.
sabbatical in the fall over in the UK, and
Right.
it made the news there as well.
Right.
And it really surprised me how different the reaction was this time as compared to when the Ewanchuk case took place
Right.
in the 1990s. And there was a lot of backlash that was suffered by the people involved in the Ewanchuk case, including by on the part of Justice Claire Leroux-Dubé of the Supreme Court of Canada. And there was a bit of a fighting match between her and Justice McClung from the Court of Appeal at the time.
Let me ask you this, just so that I'm
Yeah.
just to put it again, and keep in mind this is not my area of expertise at all. That's the Bonnet and Kringles case.
Yes,
is that
exactly.
right? You and
The
Chuck.
Bonnet and
Awesome.
Kringles case.
Awesome. Yes.
Right. So a lot of the people who spoke out about the Alberta Court of Appeal judgment in that case did suffer professional and personal backlash, and I was quite gratified to see that we didn't experience any of that negative backlash ourselves for having made the complaint in this case. Now, it may still be that some of that backlash is going on in forums that I'm just not aware of, but it does make me feel hopeful about the changes to sexual assault law that have taken place over the last 20 or 30 years, and the fact that I think people now accept that this is the law of Canada, and that the obligation on judges is to fulsomely apply that law in a way that does not reflect myths and stereotypes, and that reflects our collective consensus as a society that these are the laws that people are bound by. So that does give me some hope, even though I do remain disturbed about some of the things that actually happened in this case.
Fair enough. And actually, just as it all, and if this isn't fine, that's fine. But you indicated that you had, and they were already in the public record, the Crown's factum and the transcript. Do you have soft copies of those or hard copies?
I have a soft copy of the factum. The transcripts we can't post because they have the complainant's name in them, and because of the publication ban in the case.
Oh, okay, fair enough.
There would have to be a ton of redacting that was done before those transcripts could be posted. So we've actually, Alison, Elaine, and Jocelyn and I have gotten several requests for the transcripts.
Right.
We've just had to say we don't feel like we can disseminate those.
That's interesting, because that's well, and it's a publication ban. You're probably right about that. That's interesting.
Yeah,
because
so
I would have
without
thought you
them
could have
being
just
redacted.
well, I would have thought you could just use the black highlighter on the complainant's name, and maybe even the accused name if it would identify them. I mean,
The accused name was actually made public in the case, so it was just the complainant's name
Right.
that was that would be subject to the publication ban. But there was other identifying information in the transcripts as well that perhaps would not be quite so easy to redact. So,
Right. Okay.
yeah.
No. Fair enough. And you've read it, and I haven't, so that's fine. Well, I'll tell you what. If you can get
It
me
is too bad that it's not a reported decision, though, because I think there's educational value in people being able to read that sort of trial judgment and to see for themselves what the comments were that,
Right.
that Judge Camp made and why we took the action that we did.
Right. Well, anything that's in the public domain, I'm happy to put in the links. Like,
Okay.
for example, your blogs or the factum,
Yeah.
whatever it is you'd
Court of
like to
Appeal
put out there.
decision.
The Court of Appeal. Oh, that's you can do that on Canly, right? But like
Yes.
that's an easy link. But I'm thinking
Yeah.
more like about Dropboxing the factum or something
Sure.
like that, right? So that makes total sense to me. All right. Thank you so much for your time. I really appreciate it.
Thank you.
And thank you again. And that's all we got.